All right, let's get started. Um, Good day, everyone. This is Jeff Jenkins with the Texas Chiropractic Association. Thank you so much for attending our webinar today, Align for Success, Asset Protection and Tax Strategies for Chiropractors with TCA Friend of Chiropractic Partner, Legally Mind. And uh, very excited to have Jason Porter here with Legally Mind on our webinar. So I'll introduce him in a moment. Just to let you know, this is being recorded. If you want to share it with colleagues, about ways that Legally Mind can help you with your finances and kind of strengthen your financial position. I highly recommend it. Jason will tell you more about some of the offers related to Legally Mind. But let me introduce Jason. This is being recorded, so you again you can share, and we'll get the link out to you within 24 hours. So it's my pleasure to introduce you to Jason Porter. Jason is a keynote speaker and chief real estate asset strategist. He began investing in real estate in 1992. His portfolio has included single family fix and flip, multifamily, raw land developments, mobile and modular home developments, and resort developments. As his portfolio grew, Jason became increasingly concerned about protecting himself and his companies from lawsuits. His search for an asset protection law firm led him to Legally Mind in 2008, where he became a client. Jason hit it off with founder and owner of Legally Mind, Dan McNeff, as they share many similar interesting experiences. Eventually, Jason took a position as chief real estate asset strategist and went from client to advocate. He brings his years of experience as a business owner, investor, and strategist, along with his unique and insightful speaking style on an invaluable subject to all medical, dental, real estate, investing professionals. So I know you're going to get some great things today that I think are going to help you protect your practice, protect your family, and everything you've worked so hard to create. So I'm going to turn it over to Jason. Enjoy the webinar and thank you.
Awesome. Well, I appreciate that. Let me go ahead and share my screen here. First of all, it's always an honor and a privilege for me to be able to present for Legally Mine. As you heard in the introduction, I do not work for them. I'm not an attorney. I am a client of theirs for, coming up on, well, 18 years now. And there are the top most sued individuals or professions in the United States are medical and dental professionals, and they carry that torch well in front of anybody else. But after medical and dental, the top most sued profession are landlords. And when I started investing in real estate in 1990, I've done hundreds and hundreds and hundreds of deals. We have doors coast to coast, rental properties that we maintain. We do fix and flip. All of the liability of somebody coming on a property is the property owners. Whether that's a client that's visiting or a patient that's visiting your office or an electrician who needs to come and fix something, if they're on your premises, starting in the parking lot, it's your liability. And when there's a slip and fall, even if it's like I say, an electrician falls off a ladder from working in up in the ceiling for your Wi-Fi or whatever, it's your liability. So I got tired of getting sued, and I realized that I was missing something in my team. As we build wealth, there are people that we need to surround ourselves with. And most of us know that I need a good accountant. Most of us know that I need a corporate attorney, somebody who can do my contract law for me, somebody who can make sure that I'm obeying the law or that I am protected when I do business with other individuals. So it's contract law, corporate law. We need that on our team. And then the third one we need is a financial planner, somebody who can help us invest. Most doctors and dentists are not great investors because they're great dentists or doctors. But some are, and they put the effort into that. But a lot of them just abdicate the responsibility of their taxes to their accountant. They abdicate the responsibility of their investing to their financial planner and investing broker. But there's a fourth element that is missing for most people. It was missing for me at the time, and that's just an overall legal strategy for how everything is organized for lawsuit prevention, for estate transference, and for reduction of taxes. Accountants are not tax strategists. Attorneys are. Those are specifically tax attorneys. Accountants are not financial advisors. They're not financial. They know them, but they don't do the same deal. Lawyers are not asset protection lawyers. Most lawyers specialize in contract law, corporate law, family law, but asset protection, there's less than 100 firms in the country that do it. It's just an area of focus, highly specialized. So that led me to Legally Mine, and I've been an advocate for them ever since. So enough about me. What you're looking at here is a QR code. If you'd like to have a little bit of a follow along, this will take you to a website. It will ask you for your name and contact information. We don't use that to hammer you with any marketing, but if we need to follow up with you, we'll have that data. That is not shared or sold to anybody, so you don't need to worry about that. But we'll take you to an overview that tells you what we do. So I'm just going to leave this slide up for a moment. Go ahead and grab your phone and hit that, and that will take you to that site so that you have an overview of things. With that, I'm going to go ahead and jump right into it. Benjamin Franklin said there are only two things that are certain in life. We all know that he said it was death and taxes. I would add one more. As soon as you become wealthy, you are going to be sued in the United States. That is just part of life. And if you have not been sued yet, that's either because you haven't built enough wealth or you don't have enough patience. It's just a statistical law of averages. You will be involved in a lawsuit in the United States if you are a high income earner or somebody building wealth, somebody that has enough perceived wealth that people want to go after it. So we'll start with death. I'll address this a little bit more later. How do we organize ourselves so that we pass on as much money to our loved ones as possible? But 67% of Americans die without a valid estate plan, leaving their family fighting in a probate court. This needs to be avoided. I'll help you with that today. This one is a huge deal for me as a business owner. I know it's important for you, but 73% of all Americans overpay on their taxes. They do not receive an automatic refund because of an overpayment. You have to ask for that. It does not come with any interest. And your tax bill right now will average in America between 30 and 42% of your total income. That is your tax bill. So if we look at all of your expenses in your life, if we look at your housing expenses, your auto expenses, your insurance expenses, if we look at all of your expenses, the largest percentage of the largest line item of all your expenses is without a doubt, not even close, the income tax you pay, both state and federal. Now, again, you're all in Texas, so you're not paying the state income tax, but your property tax is astronomically high, and you pay other taxes in the form of sales taxes and so forth. So our tax bill is something that very few people spend a lot of time figuring out how to budget, how to reduce that legally. How do I get that down as low as legally possible? Everything I teach you today is going to reduce your taxes. In fact, what I'm going to teach you today about eliminating the threat of lawsuits will completely pay for the legal fees, the legal process, the entire setup process of protecting your entire estate, both business and personal. It will be completely protected, and it will be done off of tax savings. So our clients, we're the largest asset protection firm in the country by a long shot. We're the oldest as well. I said our founder in the introduction. You saw our founder was Dan McNeff. That's only under our current moniker. He actually bought a company from Jay Mitten. Jay Mitten's the father of asset protection. Started in 1968. So we have over 24,000 clients of record. Zero of our clients, 90% of whom are medical and dental professionals. The other 10% are real estate investors like myself. Zero clients out of 24,000 highly suable clients have ever lost an asset in a lawsuit. In fact, the vast majority, only a handful of lawsuits have even proceeded forth. Because once an attorney realizes there's nothing to get, the lawsuit stops. For those that did continue, the prosecution lost. There was no asset to get. And I'll talk about the consequence of that and why so few attorneys have done it here in a bit. But we're going to talk about these three things as we get going here. Now, are lawsuits a problem for you? If they haven't been yet, count yourself lucky. As I said, over 40 million lawsuits last year to the medical and dental professionals in this country. It's increasing at a rate of about 7.2 million lawsuits per year. It is astronomical. We're in an epidemic. Here's the fact, and a lot of chiropractors don't think about this. Less than 5% of the lawsuits that you will inquire in your life come from your practice. Less than five. So 95% of your risk has nothing to do with you touching human beings as a practicing chiropractor. 47% of your risk is your staff. Sexual harassment, wrongful termination, discrimination, you name it. 47% of your lawsuits will come from staff. And your malpractice won't help you at all with that. So your insurance won't help you at all. There's no way to protect that. So you have to structure yourself properly to eliminate that risk. But if we add 5% from your clients, your patients, and we add 47% from your staff, that still leaves us with a 48% risk coming from somewhere. 48% of your risk in lawsuits is from your basic personal life, driving your car, giving kids keys to a teenager and letting them drive one of your cars. Half of your risk is something that most chiropractors don't even think about. When they think about protection, they think of malpractice. They think I've got to have people sign waivers. I've got to do this stuff, and it's going to keep me from getting sued. Please understand this. I want you to write it down if you're taking notes. Insurance, whether that's on real estate assets that I own or on my umbrella liability, all insurance is to protect the people that I may hurt. And all I want is at the end of whatever damages occur, I want their attorney that they hired, their one call, that's all person to say, there's no reason to sue, settle for the insurance. Settle for the insurance. Because God bless them, if they're hurt because of something that I did or my kid did in my car, if they're hurt because of damages that I'm responsible for, they need to be compensated. But my assets should never be at risk. So that's what we're going to talk about as we get into this. In order to understand lawsuits, you need to understand causation and motivation. Causation is simply damages. A snowy parking lot, or you guys in Texas, the freezing rain thing freaked me out the first time I saw it when I was visiting my daughter there in Waco. That's your responsibility. Somebody slips and falls on your property, that's cause. If they're hurt from your chiropractic manipulation, that's cause. If they had an inappropriate thing said to them at the office, whether by you or somebody else, that's cause. Cause we can't control. You cannot be 100% risk proof. You can't eliminate the damages that will happen eventually to somebody in your life. Whether somebody's backing out of the parking lot at the mall and hit somebody, whatever, there's going to be damages. But if there's damages and damages alone, a lawsuit does not happen. There has to also be motivation. Now, motivation in every case is money. That's what motivation is. If they cannot get to the money or they cannot liquidate assets to make it money, the lawsuit will stop. It will not go forward. And for proof of that, I would just ask, how much damage is caused by on property or on people by homeless people in America today? The answer is either zero or more than zero. Well, it's more than zero. How many lawsuits come against homeless people? Now, that answer is zero. Why? Well, because there's no motivation. There's nothing to get. So there's no reason to sue. So my job in the next 45 minutes is to show you how to remove the motivation in everything you own so that the only logical choice a prosecuting attorney can make is settle for the insurance. If we do that, we've done our job, lawsuits stop, and we're able to transfer our wealth onto the next generation without risk of losing it to a catastrophic loss in a lawsuit. So that's what we're going to talk about today. To do that, we need to understand the motivation means we have to own things the right way. So here are the 4 rules. You got to have the right owner, owning the right asset. That owner needs to be an entity, and it needs to be the right kind of entity, the right type of entity. It needs to be owned in the right state. Now, you live in a good state. Texas is a great state for liability reduction because of your homestead protection. So your primary residence is 100% protected. Used to not be that way. A few years ago, you guys maxed out at $750,000 of equity, but to keep people from moving more to Florida than to Texas, they changed that law. And now you have an unlimited homestead protection for liability. But anything you own outside of your personal residence, where you sleep, that homestead, everything else is at risk. So you need to own those assets in the right state. But don't worry about your personal home in Texas. It's a good place to live for that. And then your entities have to utilize the right verbiage. So we're going to talk about each of these things as we go in. We're also going to talk about what kind of asset you own. Safe assets we all own. Those safe assets are things that cannot cause a lawsuit. High risk assets are things that can cause a lawsuit, all on their own. So a safe asset example would be bank accounts, investment accounts, retirement accounts, gold, silver, jewelry, artwork, crypto, and other valuables in your home, cash you keep in your safe, and so forth. None of these things will ever hurt anybody. So we do not want them to be owned by the same person or by the same entity that can cause damage. So right now, if you own your bank account, that bank account can be secured. It can actually be seized. It can be levied by the government. It can be levied by the court. It can be seized by the court. So we want to remove your name from these safe things so that if damages are caused by you or somebody you love, somebody you're in control of, all of these safe assets are safe. What entity do we put those in? Safe assets go into a family limited partnership. Your high risk assets, these are your office, your equipment, your land, your business interests, cars, rental properties, firearms, boats, etc. Anything that can hurt somebody, anything that can hurt somebody should not be owned by you. The worst way you can own anything is in your name. Should not be owned by your practice because we don't want your practice being sued because it owns the building that you're in and there was a slip and fall on the building. You want the building being sued, not you or your practice. So we're going to encapsulate each of these things in LLCs done the right way, and I'll teach you how that works, what state to put them in here in just a moment. So we separate these assets, we divide and conquer. Let's start with a family limited partnership for your safe assets. The family limited partnership, as I said, was brought into the United States in 1968 by the original founder of the firm I represent, which is J. Minton Law. J. Minton is the father of asset protection. He brought this entity in from England, created the first family limited partnership in the United States. The family limited partnership is a unique entity because the general partner has 100% control of the company. The limited partners have no say, no control. And because they have no say, no control, the limited partners cannot be sued. They carry no liability. The general partner carries 100% of the liability. Now, you individually would not be the general partner. You personally, your name, your social security number, your spouse's name, and his or her social security number would not appear there. You and your loved ones would appear as limited partners. That's where your social security company or social security number would appear on the entity. And you can't be sued personally because you don't have any control over the company. The company is controlled by the general partner. The general partner, however, only owns 2%. That's what makes this so absolutely unique in entity creation in the United States. Very, very few, statistically, very few attorneys know how to build them properly. And please don't think LegalZoom is where you want to go to get this done. It has to be done the right way, using the right verbiage in order to work properly. Now, the 2% ownership, who owns that? Well, a company. A company owns that. Now, that is a financial management company. The financial management company is the general partner, and it could be sued if its assets caused damages. Well, those assets that it owns are all safe assets. They don't cause damage. But if a court got squirrely and decided to go ahead and let a lawsuit come against it, the only thing at risk is 2%. Now, who is this management company? That management company is you and your spouse if you have one. Now, it can be sued, but in the United States, people and companies are viewed separately. So it has an EIN number, it can be sued. It does not transfer over to you personally because you personally didn't cause the damage. That entity caused the damage. That entity can be sued, and it only owns 2% of your safe assets. And unless your last name is Musk or Bezos or Gates, nobody's going to want to sue you for 2% of your safe assets. Now, this is how it was set up in 68. In 1970, a lawsuit came against one of our docs, and we lost. This was in the state of California. The court said, this is just a shell game. You're trying to protect this lawsuit. We order the family limited partnership dissolved. We appealed to the appellate court, Ninth Circuit Court, San Francisco. We lost again. And that did not look good for us or for the future of the J. Minton Law. And fortunately, we had a client that had some money, and he believed in what we had set up for him. So he helped us take this all the way to the Supreme Court. And at the Supreme Court in 1974, the Supreme Court ruled 9-0 in favor of supporting the family limited partnership and keeping it in place. No money was ordered out, no assets were ordered dissolved. And as a result, we have Supreme Court case precedents. And if you understand the law school is taught on sue and defend. It's all 100% based on case precedents. So they will quote a case in Brown versus Board of Education, and there is the precedents that provides the court with the rationale to how they should rule on this one. And overturning precedents is difficult at best. And when it's a 9-0 Supreme Court, U.S. Federal Supreme Court, it's not getting overturned. When was the last time the court even ruled on anything 9-0? Probably 1974. So this has stood for a long time. I want you to just note this, listen to this, write it down. But since 1974, there has never been a properly drafted family limited partnership that has ever been successfully sued. It just doesn't happen because 2% isn't interesting. If you had $1 million of safe assets, if the court even allowed it, the most that would be at risk would be $20,000. The attorney taking that case on contingency would receive 40%. So it's an $8,000 win for the attorney. It doesn't even cover the court costs. So they're not going to move forward. What we hear when if a lawsuit comes against a family limited partnership is what we want to hear, which is there's nothing to get here. Settle for the insurance. That's what we want the prosecution to say every time. There's nothing to get here. Settle for the insurance. As long as that is what the result, everybody's playing to win. So that's the way it goes. Now, your high risk assets can cause a lawsuit. They are much more likely to be sued, exponentially more likely to be sued. So let's talk about LLCs, how they're done properly and how they're done wrong. An LLC is a limited liability company. For a history lesson, it started in 1987 in the state of Wyoming. Wyoming had 3 attorneys that had formerly worked for J. Mitten Law, who had become Wyoming state representatives. They then went to the state and said, we need to create an attractive place for companies to come and domicile their businesses in Wyoming so we can make money off of that. There's not a lot of reasons for companies to put their company as domiciled in Wyoming. You've heard of Delaware Corps and Nevada Corps. Wyoming Corps at the time, nobody had ever thought of. So they started the LLC in Wyoming. It became wildly popular. Within 3 years, they were in all 50 states, and it is the right entity to own high-risk assets in. Now, the problem is most attorneys are not trained on asset protection, not specializing in asset protection, so they commit a cardinal sin. They say, how much insurance do you have? Well, I have a $5 million umbrella policy. Okay, so we're going to take $5 million worth of stuff, and we'll put it in one LLC. Well, this is a really bad idea. You do not mix assets in LLCs. That's not the way it was created. It's not the reason for them. Why? Because if damages occur, and they will, these are high-risk assets. If there's a slip and fall at the building, now because the same company that owns your building owns your equipment and owns your rental property, all of a sudden all 3 are involved in the lawsuit. This is not the way that LLCs were designed to work. We don't want we want to divide and conquer. We don't want to unite unnecessarily these assets. So the right way to do it is to encapsulate every high-risk asset in its own LLC. Then if damages do occur at a slip and fall at the office, that lawsuit is contained to that entity only. I can't sue Burger King because McDonald's made me sick. This system of dividing and conquering is what is used by large corporations all over the country. Disney, for example, when you go to Disneyland, you pay Disneyland to go in. You ride the rides for free. The rides are not paid for. You are paying for admission to the park. Everything in the park is free. Now, here's what a lot of people don't understand. Every ride at Disneyland is owned in a separate LLC. A damage has occurred on car number 4 of Thunder Mountain Railroad. There was a broken neck and it resulted in a death. Now, a lawsuit came against Disney only for prosecution to discover that Disney does not own Thunder Mountain Railroad. That is owned by a completely separate company. And you cannot sue Disney because that company did damages. So contain the damages there. Now, under the law of an LLC, I'm going to teach you this. This is This is a high level understanding, so I'll just go briefly over it. Okay. Every state has something called a charging order. Charging order is what a judge has to. It's not, maybe they will use it. They have to use the charging order in order to direct profits to somebody who wins a lawsuit. So the plaintiff, if I sue Disney and I win, the charging order says you cannot have the asset, but you can have all the profit generated from it. So exactly how much profit is generated by Thunder Mountain Railroad LLC, which is not owned by Disney, how much profit is generated by them? Zero. The money is paid to Disney. You ride the rides for free. And a great example of this is every parking lot of Walmart is owned in an LLC, not owned by Walmart. Slips and falls in the parking lot are the most common cause of a lawsuit coming against Walmart, only to find out the Walmart doesn't own the parking lot. The company that owns it generates zero revenue. You cannot have the parking lot charging order, but you can have the profit from it. There's zero. Now, my favorite example of this is actually Park City Mountain. I grew up and raised our family in Utah before moving here to Las Vegas, or Henderson, Nevada is where I am right now. But Park City Mountain, every 150 feet you descend that ski resort, you're in a new LLC. They subdivided the mountain horizontally for liability protection. Now, if there's an ungroomed area of the ski run and you slip there, fall, hurt yourself, you cannot sue Park City Mountain, the one who took your money, because they don't own the thing that caused the damage. It contains the damages only to that entity. That entity generates no revenue. Therefore, there's nothing to get. You cannot have the asset. You can have the revenue from it. So remember that. That's the special thing about the way an LLC was designed. You cannot have the asset. You can have the revenue from it. Well, with that understanding, let's go to the problem here. Because the American Bar Association is the strongest lobbying body on planet Earth, far greater than the gun lobby or the teachers lobby or the healthcare lobby or pharmaceutical lobby, the strongest lobbying body on planet Earth is the ABA, the American Bar Association, followed up by the American Trial Attorneys Association. Why? Well, because we have three branches of government. Let's start with the legislative branch, the ones that make our laws. What percentage of state and federal legislators are bar admitted attorneys? Greater than 90%. Then we'll go to the second branch of government. That second branch of government is the executive branch. The executive branch would be your governors and your president of the United States. Now, I'm not talking about those individuals. I'm talking about their cabinets. What percentage of that cabinet, the executive branch, what percentage of that of them are bar admitted attorneys? Well, interestingly, over 90%. Then we get to the judicial branch, the third branch. They're the ones that that adjudicate our laws. And that judicial branch, what percentage of them are bar admitted attorneys? Well, that'd be 100%. So we have laws made by attorneys, enforced by attorneys at the executive level, and adjudicated by attorneys. So left or right isn't the issue. The issue is all attorneys do the bidding of the American Bar Association. This is why they create laws that make no sense. For example, if we really wanted to reduce healthcare expenses, could we not pass a law for tort reform like every other country has? In the UK, your right index finger is worth a finite amount of money. Death is worth a finite amount of money. Your kidney is worth a finite amount of money. Every part of your body that can be damaged is worth a finite amount of money. This keeps their healthcare costs low. We don't have that. We have a bar association that wants the next lawsuit to be even bigger. And unless and until we change that, healthcare costs cannot come down. Now, that's not going to change because our laws are made by attorneys, enforced by attorneys, and adjudicated by attorneys. So we have to be smarter. We have to use their laws against them. Let me explain. Judges in all 50 states now can pierce the corporate veil of a closely held company and sue the owners of it individually. So why own an LLC? If you own an LLC in all 50 states, they can sue you personally. They can sue you personally. And now it has to be closely held. Closely held, what does that mean? That means small business. Well, that's determined by the state. The most egregious definition of closely held is the state of California. They say if you have 99 owners or less, you're closely held. All 99 of you can be sued personally. So you could have a chiropractic group with 4 owners. One of them commits sexual harassment. The other 3 are still going to be involved in that lawsuit. They didn't do anything wrong. but all four can be sued personally, which means everything they personally own, bank accounts, houses, everything they personally own is available. Okay. Now, in 39 or 38 states, 39 states now, judges can dissolve the entity altogether. They can just say, I'm just getting rid of the LLC, it's gone. They can also foreclose on the membership. They can say, I'm going to take you, Dr. Smith, and I'm going to take your ownership of this, and I'm going to give it to the plaintiff until they get their judgment. So let's say I win $1 million against you. They just take your ownership, give it to me, and I keep all the profit until I get my $1 million. So that's how they work around the charging order. Now, in order to beat that, we have to use the law. So we do not want our names on any of these LLCs. We do not want our names on any of these LLCs. Instead, we want all of the LLCs owned by another entity. This is called a holding company. And I know you've all heard about holding companies. Why do we need a holding company? Well, for multiple reasons. Number one, let's just talk about practicality. If I have an LLC for every one of my hundreds of properties, let's say I have 200 LLCs. Well, that's a nightmare for accounting. Well, all of those LLCs are owned by one single holding company. All the profit flows to one single holding company, which means I'm only filing one additional tax filing. That does not make my accountant angry. Now, if they had to file a tax return on every one of those sub-entities, that's a problem. So it's a law of disregarded entities. We do not have to file for them. We file to their ownership. So it does not complicate your life. There's one additional filing, and that's the way that works. So number one, we want a holding company to simplify our bookkeeping, simplify our accounting, and make our accountants happy. Number two, only the holding company can be sued now. So if I sue the LLC, pierce the corporate veil, and say, who owns that? I'm going to sue them. Well, now I have to sue the holding company. So let's talk about where to put that holding company. It should not be in Texas. The holding company should not be in Texas. I don't know if you guys have heard this, but Austin has gotten weird. And judicially, Texas is less conservative. I'm not talking about political conservative or liberal. I'm talking about judicially, their temperament has become more progressive than it used to be by far, and it's leaning that way more and more. You're seeing judgments in Texas that 10 years ago you wouldn't have dreamed of seeing. Well, it's happening. So we do not want to domicile the holding company in the state of Texas. There's only one state that we will recommend. That state will not dissolve. 38 states will. They will not seize assets. Florida and Texas will not seize your home, but they will seize other assets. They will not foreclose on your membership. 49 states will foreclose on your membership. There's only one state that won't do that. Most states have a very weak charging order. Now, Texas's charging order is fairly strong, but the best is Alaska. Alaska will not dissolve, they will not seize, they will not foreclose, and it has an extremely strong charging order. So let's just say for a moment I sue Dr. Smith and I win a judgment. Well, excuse me, I go to sue Dr. Smith because of whatever, because of something happened at the office or because their son hit my son in a car accident and killed my high school quarterback. By the way, NIL is now being paid in Texas. It's legal to pay a high school kid to play. And if they're getting high school money, they're also going to get college money. So I'm going to sue you for all the money that we lost in college. And then I'm going to argue before the court that they were also going to make it to the pros. So I'm not just seeking what your $300,000 liability policy. I'm going for pain and suffering, loss of income for my son who's now dead because of your son. And we're looking for $400 million. These are the kind of judgments that are being doled out now from a loss of a high school life. So we're going for a big number here, whatever that is. Let's call it 30 million. Doesn't matter, whatever the number. And you don't have enough cash to satisfy that. So how do we do that? We say, I'm going to sue the LLC that caused the damage. I'm going to sue the person that caused the damage. And I see, that car's owned in an LLC. Who owns the LLC? Some company in Alaska. Now, from Texas, I have to hire an attorney in Texas, and then we have to hire an attorney in Alaska to co-counsel because they need to be bar admitted in Alaska. This lawsuit will happen pursuant to Alaska law, not Texas law. Now, Alaska says, yes, indeed, the damages were caused. You cannot have the asset, but you can have all the cash it generates. Exactly how much cash did that car generate? Zero. As soon as an attorney sees this, they're going to say there's nothing to get here. Settle for the insurance, which is what we want them to say. This is why we don't want you owning safe assets, because if you get named personally, we want them to see there's nothing to get here. Okay, so that's the way it works. We use the charging order to our favor. The Now, in order to take it one step further, we need that holding company, if not everything below it. We need that holding company to utilize the right verbiage. Now, what verbiage am I talking about? Standard verbiage controlled by the American Bar Association in every template driven LLC in the country. Standard verbiage is what we call pro rata distribution. Pro rata distribution is what the court uses with the charging order. So remember, I sue you and I win $1 million judgment. The court says you cannot have the asset, but you can have all the profit. Now, if there is profit there, let's say I sue your practice, there's profit in your practice. So I get the profit. It does not flow to you at the end of the year on a K1. It does not flow to you on your individual taxes. It flows to me until I get my $1 million. That's the way the charging order will work. Now, how hard are you going to work if you can't make any profit? Well, not very hard. So we have to manipulate the standard language. You see, the standard language underwritten by the American Bar Association is called pro rata distribution. What it says is all of the profit flows to the owner of the entity at the end of each fiscal year. That is when the judge can grab it. Okay. Remember, the charging orders awards the judge the financial control over the entity, and it allows the judge to set a salary for you, the doctor. Say, hey, you're going to live on 90 grand a year until Mr. Porter gets his $1 million. And that's true for you, your partners, whomever's being sued. We do not want this. So what we want to do is go backwards in time to 1974 Supreme Court and utilize the distribution language of a 9-0 precedence at the Supreme Court. Do you remember the Family Limited Partnership? Its standard language, its language is non-pro rata distribution. Non-pro rata distribution effectively blocks the judge. Now, this is not standard in any entity any of you own. Non-pro rata language, verbiage says this: only the general partner can order a distribution of profit, and I can retain it year over year over year ad infinitum. So, now I'm going to sue Dr. Smith. I'm going to win $1 million judgment. He has non-pro rata language in Alaska, and here's what the court will say. You cannot, using the charging order, you cannot have the asset. You can have all the profit that it generates whenever that profit goes to Dr. Smith. But Dr. Smith, as the general partner, you can retain your profit year after year after year until you're dead. Well, if Dr. Smith cannot be forced by the court to issue profit to me, when will he just choose to do that? Never. I'm never going to get paid because the court cannot force him to pay me. Now, that sounds illegal. No, we're utilizing the law passed by the legislators that you voted for. They just don't want you to know about this law. This is not standard language law. In fact, most attorneys, my dad included, who was one of the top trial attorneys in the state of Arizona, didn't even know that you could have non-pro rata distribution in an LLC. You can. When this happens, I'm not going to get paid, which means my attorney won't get paid. And what are they going to say when they see non-pro rata language and they understand the case precedents? We'll tell them about Legally Mine. We'll say, here's the case precedents, here's the law, go ahead. What are they going to say to their client? They're going to say there's nothing to get here, settle for the insurance. And the last nail in the coffin of a lawsuit coming against you is the IRS. The IRS, I live in Henderson, Nevada. I'm 20 minutes from the Strip in Las Vegas. Most people do not understand this. When you win more than $1,500 on that Las Vegas Strip, you will not leave that casino with money until your taxes are paid. You see, in the United States, the IRS says that winnings, whether that's lottery or lawsuit or gambling, winnings are taxed above a certain amount. Winnings are taxed above a certain amount. Well, if you win a lawsuit judgment of $1 million against me, the IRS comes in, and using ruling 77-137, the IRS says this: a plaintiff using the charging order will have to pay income tax on any monetary judgment, even if there is no distribution from the defendant. So when I win $1 million lawsuit against you and you have non-pro rata language in an LLC in Alaska, Alaska upholds the charging order and says you cannot have the asset. You can have all the profit whenever Dr. Smith decides to distribute, Dr. Smith retains those profits. This year, I get a bill from the IRS on my winnings of $1 million, even though I didn't get it. Now that's going to bankrupt me because I'm going to owe $380,000 of income tax. I'm now going to sue my attorney who should have known better. You see, an attorney takes an oath. They're a fiduciary above all else. Have you ever heard of an attorney misusing the trust account as a fiduciary? They go to jail. They lose their bar admission and they go to jail. They're not going to take this on because they cannot prejudice my financial stability. If they do, they're liable. I will sue them and I will win. Their E&O insurance will kick in and pay the $380,000 for my income tax. They will lose their license to practice and maybe worse. And they're going to also have to pay me for pain and suffering. So it doesn't happen. As soon as an attorney sees this, what do they say? They say there's nothing to get here. Settle for the insurance because that's a better choice than getting a tax bill. Now, when you put it all together, and we own our safe assets in family limited partnership, and we own our high risk assets in LLCs, not owned by you, but owned by a holding company in Alaska. And that holding company utilizes non pro rata language, which allows you not to be forced to pay a distribution. All lawsuits stop and they simply settle for the insurance. Now, that is until you die. You see, when we die, our kids go crazy. So we have to put one more entity in place that sits over the top of everything. Some of you on the call right now have already done this step. You just didn't do anything correct below it. This step is called a living trust. We do not use a will. A will is a document for poor people. Write that down. A will is a document for people who don't have anything to pass on. You see, a will take the estate to probate court. Probate will then make sure that everything is distributed properly. But it can be contested. It can be fought. So if you have assets, you don't want your kids to fight each other post-mortem. And they will, because when you're not here, kids melt down. So you have to put that in a living trust. That's the only right way to do it. Don't do an irrevocable trust. Do a living trust because it can change. You can change everything underneath it. So it is what executes your will, not a probate judge. Now, the best part about a living trust, if you don't have one, the best part about a living trust is it can't be disputed, it avoids probate, and it protects everything under death. But the best part about it is the reassessment or reappraisal of the assets underneath it. So in a will, if I bought a house for $300,000, I die and leave it to my estate and it's worth $2 million at that time, well, my cost basis was $300,000. The kids sell it or probate court sells the house for $2 million. That's a $1.7 million gain at a long-term capital rate. They're going to pay 24% of that. The estate will pay 24% for federal long-term capital gain on that. And additional depending on the state where the property is. Now, I don't want that to happen. I want my kids to get all $2 million. So a living trust allows for a new cost basis at the time of the last spouse's death. So I die or my wife dies, the last one of us, and it's reappraised at $2 million. That becomes the cost basis for the children. They sell the $2 million asset at a cost basis of $2 million. There's a $0 capital gain, no tax owed. So we just saved $400,000 of our estate on one property because we took the time to set up an $8,000 or $10,000, $12,000 living trust. Now, those of you who have a living trust, you know the cost. The more assets you own, the more expensive it is. On the cheap side, it's $5,000. Don't use LegalZoom, please. Use an attorney, and if you're using an estate attorney, it's going to be somewhere between $5,000 and $12,000, depending on how much you own. But it is essential to set up properly. And then it's essential to maintain. Every time you sell an asset underneath the trust, you need to renew the trust. You need to update the trust. So there's maintenance required. And a lot of people get the trust and never update it. A lot of people get the trust and never put anything legally into it. You actually have to go down to the county and change the ownership of things to the trust. So there's a process involved, but is it worth it? Absolutely. Absolutely. When we have a a living trust set up that is over the top of everything. When we die, everything flows into it, and then the trust executes our desires post mortem. Lawsuits stop all the way around, not even from a contested estate. So that is what we do for our clients. We've done it for 24 years under our current moniker, and 46 years since Jay Minton Law started doing it, and over 24,000 docs. Nobody's lost a single asset in a lawsuit. And that doesn't mean that there hadn't been things brought. And I'll just tell you one from last year. One last year was brought from the state of California. The state of California sued one of our docs, not because of liability, but because of workers' comp issues. There was some mistake done at workers' comp. Now, everybody will tell you you're not going to beat the state on workers' comp. Well, they came after him personally, tried to take assets. Couldn't touch him. Couldn't touch a thing. So what we do works. If the state of California couldn't get to anything, nobody's going to get to anything. And that's just been the way it's been for a long time. Now, I told you that setting yourself up this way to stop these lawsuits is completely paid for with tax deductions. I'm confident of that because most docs just abdicate the responsibility for their tax strategies to their accountant. And accountants are not tax strategists. They're really glorified compliance officers. They make sure that everything's submitted on time and everything is substantiated. They make sure they'll often say, we don't want to do that because it could trigger an audit. You will never hear an actual tax strategist utter the words, we don't want to do that because it could trigger an audit. No, a tax strategist is a lawyer, and they say this is legal and this is illegal. So we're going to do the legal. It won't trigger an audit because it is legal. See, an audit happens because they think you broke the law. If they know you did not break the law, you can push the envelope all the way to the edge of the law, but we don't go beyond that point. Now, too many high-income earners in the United States are not pushing the envelope nearly as well as they could. I'll just explain. Here's a few 73% overpay. Here's a few deductions we help our docs get. When you organize yourself properly, you will save money on FICA, which is your Social Security tax. By having a financial management company, that general partner of the family limited partnership, filing as an S corp, you're able to run a vast number of expenses through that entity. For example, my wife and I, that entity is a financial management entity. That's what it does. It manages the finances of its clients. It has exactly one client, me. So it looks for ways to invest our money. Any money it spends in the pursuit of figuring out how to invest our money is deductible. So that company took a trip to Tahiti 2 years ago looking for Airbnb properties. We stayed in some Airbnb properties. We went around and looked at a few. We didn't decide to buy any because we couldn't find a good enough deal. But you know what? We went to New Zealand the year after looking for Airbnb properties, and we got to write that trip off too. Now, that sounds like I'm cheating the system. No, I'm using the system that was created by the legislators that you and I voted for. Now, I'll be darned how many of them are using the loopholes that they created? Well, all of them. So I'll be darned if I'm going to let my legislators who work for me take advantage of loopholes that I'm not taking advantage of. No, I just need to know what the loopholes are. It's not loophole. I don't even like that term. It's just obeying the law. Here's another one. IRS Section 280AG. IRC Section 280AG is actual code. That's the code. You can give that to your attorney, or to your accountant, rather. That code says that every American is allowed to rent their home. You can rent your house 14 days a year, and you do not have to report the income of that rental. So let me explain that here in Las Vegas. Okay, I'm in Henderson's next door. So I have the right to rent my house 14 days a year. I can put it on VRBO, Airbnb. I can rent it 14 days. I can keep all of the money. And I don't have to report that money, 14 days of it. I don't even have to report it as income. It's just free cash. Most Americans don't know they can do that. You don't have to own your home. You could be renting your home. It doesn't matter how large your home is or where your home is. You have the right to rent it. Some people call it the Augusta Clause because of Augusta, Georgia. That's the legislator who brought it forward to scratch the back of his rich people from Augusta, Georgia. They wanted to rent their homes during the Masters, and they didn't want to have to report the income. Well, that's the law. It's been the law for decades, and they receive enough money during those 2 weeks of the Masters that it completely pays for their mortgage for the year, so they get a free house. So that's the way the law works. But I am not going to rent my house in Las Vegas area to a Raiders fan. Can you imagine the damage they would do during a Raiders game? So no, we're not going to do that. Instead, we rent our property 14 days a year to a company. Our own company rents our house. So we take our top line revenue, gross revenue, and we rent our home for corporate meetings, one a month and two parties. And so those are 14 rentals. We rent the entire house out from ourselves personally. Corporation writes ourselves personally a check. And we have a lease agreement that needs to be done. There's paperwork that needs to be done, but when it's done properly, go ahead and audit. It stands. In fact, it doesn't trigger audit at all. But if they did, it would stand. And I get to write off the square footage of my home. I'm not going to tell you how large it is, but I get to write off the entire square footage of my home because we rent the entire house. And we get to do it at the average price per square foot of the conference space in my area. Well, what's conference space in Henderson and in Las Vegas? It's extremely expensive. So I get a daily acceptable rental amount of a little over $3,000 a day for my space. Let's just bring that down to 3 grand. 3 grand times 12, that's $36,000 off my top line. Whoop, gone. I get to no tax on that. Well, at my income tax rate, that's $12,000 saved in income tax. That's a whole lot better than home office deduction. It's $12,000 off of my income tax. That alone pays for setting up the entire lawsuit prevention strategy, setting up the living trust, setting up all the LLCs, setting up everything to protect yourself. That one deduction, it's massive. Here's another one, income shifting for college and minors. I would also add seniors. If you take care of your parents, if your parents are your financial responsibility, listen up. Don't give them money. Don't give your kids money. Don't pay for their school. Hire them instead. When our kids went to school, we utilized this strategy. And whenever they needed money, we would have them invoice us for social media consulting. They would invoice us. They would write a report, 1 or 2 pages on what they thought we could do with our website to improve, with our social media to improve. And then they would invoice us. If they needed 4 grand for tuition or 10 grand for whatever, invoices. We would then pay the invoice. That comes off of the company. So I'm not paying any income tax on that. It goes on to their income. Now, at the end of the year, they get $14,000 of free money. They don't have to pay any income tax on it. And then their income tax rate grows as their income grows. So it scales up. Well, just pay the income tax for them if it's over 14 grand that you shift to them. If it's under 14 grand, you just saved all the income tax on the money you gave your children, which at 30%, you saved another 3.5, 4 grand right there. So huge savings. Now, we can do that for our minors, our children. We can put them to work at your office, cleaning toilets, cleaning bathrooms. Starting at the age of 8, you can start to pay them. And that comes off of your top line. It goes on to theirs, $14,000 free, income tax free. I even start our grandchildren as models. So in our websites, my wife and I's websites, we don't use ugly models. We use our children and grandchildren. And by using them, I'm able to pay them a modeling fee starting at the age of birth. That modeling fee is pre-tax for me for the business expense, and then it is taxable for them up to the $14,000 range. What we do is we take 7,500 of that, that's this year's amount, and we fund a Roth IRA for the kids starting at birth. We take the balance and put it into interest-bearing accounts for them that are taxable. But we begin that savings plan far more flexible than a 529. It's a great way to go. One last thing, our senior parents. When my father became my financial responsibility, he was, as I told you, one of the top trial attorneys. He was also a good corporate attorney. I became his only client. So when he went into the assisted living and he needed me to take care of all of those bills, I simply said, Dad, I'm going to go ahead and invoice you and I'll pay your income tax. So I became his only client. He became my corporate attorney. We ran that as a company expense, totally legal, above board. He invoiced for every dollar that I gave to his maintenance and care. And I got the tax savings for doing that. His income rate at his age, because all he had was that for income and a little Social Security, was far lower than my income tax rate. So lots of ways to shift income there. Those are the 3 that I'm going to talk about here, but we have others. Now, These are some of the standard ones that you receive as a client of ours that are going to save you more than you pay for our services. But if you need to save more, if you need $100,000 savings on income tax or three or $400,000 savings on income tax, there are things that we can introduce you to, companies we can introduce you to that can do licensed professional deduction, R&D, captive insurance plans, structured losses. There's lots of ways to reduce your income. Those services are through third-party providers, and they have their own fees that they charge to do that. The way we don't recommend you to anybody, you have to pay up front, though. What we would do, for example, if you had R&D credits of $200,000 of credit, we would send you to a company that will get you the $200,000 of credit if you qualify, and they do it for a fee on their side, whatever that is, 10, 15, 20%. But you only pay it on money they find or save you. So it's not, most of our clients don't use it. Some of them do. It's a great strategy for them. Regardless, these strategies pay for our services. So let me switch over and talk about what is included with our services and how that's structured. As I said, we've been servicing professionals for over 40 years. I need to update the numbers here. We have over 24,000 clients now, no lawsuits, continued dramatic tax savings. If you were to go out there and set up a structure similar to what we do for our clients, and you use local attorneys that specialize in estate planning, and then attorneys that specialize in corporate planning, and attorneys that specialize in tax strategies, you will pay to set up a similar structure somewhere between $25,000 and $45,000. We keep everything in-house. We've done it exclusively. This is all we do, and as a result, our fee is $13,800, unlimited number of entities, regardless of what you own, for everybody in your household. So if you have a minor or a child that's still your financial responsibility and they've got a business on the side, we take care of that. If you have a parent that's living in your household and their estate's not properly set up, we take care of that within the same fee of $13,800. It really is the most cost competitive way to completely protect yourself from lawsuits and organize your estate for post-mortem issues that you'll ever find. Now, through your association, we provide a discount. I want to explain why, because it sounds kind of cheesy. This is a good price at $13,800. Why do we give you a discount? Well, because I'm talking to a bunch of you at one time. It's a lot more cost effective for us to have a conversation with 9 or 10 or 15 or 50 of you than it is for us to talk to you one-on-one if you understand marketing. So this is just a great cost savings for us to be able to do this, but it does need to be time sensitive. And we do that because of the law. When you offer special incentive pricing, it needs to be limited in scope. So I am going to offer a discount of $9,000 to anybody who has a meeting with me in the next 2 days. I'll provide you a link. You will book that. That will be Thursday the 15th or Friday the 16th. By the end of business, Friday the 16th, if you're not enrolled, the price goes back to our retail. Just call our offices at legallymine.com and you just give them a call and they'll take care of enrolling you at our standard rate. To get these savings, we need you to act. There's several reasons why I do that. Again, it's marketing. It's also because if you don't take advantage of something when it's first offered to you, and you put it off, when does it typically happen? Well, it doesn't. And some of you have been thinking about organizing your life and your estate and your risk for years, and you haven't done it yet. So we're providing you an incentive to do that. It takes about 3 or 4 hours of your time. It takes us about 50 or 60 hours of our time, our paralegals' time, our lawyers' time, and it's all included. Now, that is not the only fee. I do want to be completely candid. There's a retainer as well, because the first year we're going to be on the phone over and over again with you as we get you accustomed to this structure that we create for you. We do all the creation, we do all the filing at a state level, we do all of that for you. We do the minutes, the maintenance. So all of that is included, and there is a retainer fee. The retainer fee is $200 per month. It is required to be paid for the first year. That starts 1.5 months after enrollment. So on the 15th of the following month, that $200 a month starts. It goes for a year. It includes an unlimited number of conversations with you, your attorney, your accountant, your financial planner, whoever needs to be involved, your children, your parents, whoever needs to be involved. Rather than charging a lawyer's fee per hour, this is a much cheaper way to go. So we do that. After the 12th month, you can decide if you want to keep it on or not. Most people do, so that they have access to everything that we do. Now, that is guaranteed that we will save you more than you spend year one in your tax savings. If we do not do that, we put it in writing, we will write you a check for the difference. So 12 months from now, when you're filing taxes for 2026, you will have saved more than you invested in this program. Now, not all of you need our $9,800 program. We have some programs at a little lower rate. It just depends on what's appropriate for your estate. If you would like to have a one-on-one conversation with me, take advantage of our deepest savings, and get yourself taken care of, here is the link. So take a quick picture of that. It's a long one. I use Calendly for my calendaring. So it's calendly.com/real good deeds. That's me. That's the book that I wrote about real estate investing. Real good deeds slash legally dash mine dash discussion. Let's just have a discussion. It is a long URL. I don't have a QR code for it. I'll give it to you one more time. Calendly.com/real good deeds /legally dash mine dash discussion. Let's have a call. So I appreciate it, Jeff. If you have any
Jason,
questions
thank you so
for
much.
me,
Great information. And
thank
guys,
you.
the replay will be available within 24 hours. If you think you know of a colleague that would be interested and this might be helpful to them, forward the webinar replay, and we'll put you in touch with Legally Mind. Thank you guys so much. Thank you again, Legally Mind. Thank you, Jason. You guys have a great day.
Thank you. Bye bye.